Ever think about how that little I agree button online, the one it actually carries the weight of, like a real contract?
It's pretty mind-blowing when you think about it.
It is. We're swimming in contracts every day, right? Grabbing a coffee, signing for an apartment. But how often do we actually stop and think about what makes them stick? Why are some promises rock solid, legally speaking, while others, well, not so much? That's what we're diving into today.
The wild world of contract law. And trust me, it's way more interesting than it sounds.
Oh, it definitely is. We'll be dissecting what makes a contract enforceable, digging into some seriously fascinating cases where agreements went south. Think of this deep dive as your crash course on not just your rights, but also those potential landmines when promises get messy.
And we've got some seriously juicy material to work with. Excerpts from a textbook on contract law. The heavy stuff. The real deal.
Plus some case law that reads like a courtroom drama full of twists and turns. Ready to jump in?
Absolutely. Let's do it.
All right, so before we get into the drama, let's start with the basics. What exactly is a contract in the eyes of the law?
At its core, a contract is a promise, but like the kind that the courts will actually enforce. The catch is, not every promise you make at a bar at 2 a.m. is legally binding.
Right. So what's the magic formula? What elevates a casual, I'll do it, I promise, to a you better believe this is happening kind of agreement?
So you need a few key ingredients for a contract to really hold water. First off, you need a crystal clear offer and acceptance.
Yeah.
Both sides got to be on the same page, no confusion about who's promising what. Second, everyone involved has to be in their right mind, of legal age, and fully aware of what they're signing up for. We call that informed consent. And maybe the most important piece, there's got to be an exchange of something valuable: money, goods, services. Lawyers call this consideration. It's like the quid pro quo of contract law.
Okay, so it's not just about saying pinky swear and calling it a day.
Not quite.
There has to be something in it for both sides, and everyone needs to be crystal clear on what they're getting into.
You got it. And this is where things get really interesting, because even when all those elements are in place, there are still situations where a contract can fall apart. We call them unenforceable. And believe me, the reasons can be wilder than any TV show.
Okay, so we've got our contracts all nice and defined, signed, sealed, delivered. But I'm guessing it's not always smooth sailing from there.
You'd be right. It's rarely that clean cut in the real world.
Right. So tell me, what are some of the situations where a contract, even when it seems airtight, can completely fall apart?
Well, sometimes those agreements are anything but fair, and that's where the law steps in. To draw a line in the sand, that's where we get into things like duress, misrepresentation, unconscionability.
Whoa, okay, those sound intense.
You can be.
Let's break them down. Let's start with duress. What does duress even mean when we're talking about a contract?
So picture this. You're backed into a corner, forced to sign a contract under some kind of serious threat, like you're basically being strong-armed into saying yes. That's duress in a nutshell. It's the legal equivalent of holding a gun to someone's head, metaphorically speaking, of course.
So not just everyday pressure, but like a genuine threat that takes away someone's ability to freely choose.
Exactly. And courts have seen it all, believe me. A classic case is Austin v. Laurel. In this case, a subcontractor feeling the heat, right on deadline, threatens to bail on their contract unless the contractor agrees to this massive price hike.
Ouch.
Yeah, a real pickle. And the contractor, caught between a rock and a hard place, agrees. But later on, the court questioned whether that agreement was truly voluntary, given the insane pressure involved.
Man, that's a tough spot to be in. It just shows how important it is to recognize when someone's trying to use your vulnerability against you, to exploit the situation.
Absolutely.
Speaking of unfair deals, misrepresentation. We've got Spies v. Brent in our notes, and this one sounds like a cautionary tale if I've ever heard one.
Oh yeah, this one's a classic buyer beware situation. Imagine, you're buying this idyllic resort, sunshine, beaches, the whole 9 yards. But then you find out the previous owners, they weren't exactly truthful about how profitable the place actually was. And get this, the contract. It even had a clause saying the buyers weren't relying on any verbal promises.
Hold on, so even with that clause in there, they weren't stuck? Can you really just write away responsibility for, straight up misleading someone?
That's where the law gets tricky. See, there's a difference between, salesman puffery, this car drives like a dream, and stating actual verifiable facts. The court in this case decided that, clause or no clause, the buyers had been misled about some pretty crucial information. Stuff that directly influenced their decision to buy.
It's about being real, about not hiding behind legal jargon when it really matters.
Exactly.
Okay, so that brings us to Unconscionability, a word I'm pretty sure I've never used in my life.
It's a mouthful, right?
It is. What does it even mean?
Basically, it's when a contract is so ridiculously one-sided, so outrageously unfair, that it would make your jaw drop. Think of those infamously long, jargon-filled contracts we all blindly click agree to online.
Ugh, don't even get me started. Scrolling.
Yeah.
Just to download an app or whatever. But is that truly a meeting of the minds, you know? Like, is it fair to hold someone to a contract they couldn't reasonably be expected to understand?
That's the million-dollar question. And it was at the heart of the Henningsen v. Bloomfield Motors case. Imagine buying a car, but the warranty, the thing that's supposed to protect you, is buried deep in the contract, like page 57 in tiny print.
Ugh, the worst.
The worst. So the court recognized that in this situation, the manufacturer held all the cards, right? They used their superior bargaining power to basically pull a fast one on consumers.
It's not just about what's written down, but like the spirit of it all, the fairness and the transparency. It's like contract law has a conscience, making sure things stay.
All right.
Right.
That's a good way to put it.
So we've been talking a lot about fairness and transparency in these agreements, but what happens when someone might not fully grasp those terms, you know, because of their mental state?
Right.
Like, let's say someone's going through a mental health crisis. Is their signature on a contract, is that really valid? It feels like ethically, legally, it's murky.
It's a tough one, for sure. The law does recognize that for a contract to be truly binding, both sides, everyone involved, has to be of sound mind. They have to be able to understand what they're agreeing to. But when you start talking about mental capacity, well, it's not always so black and white.
So how do courts even begin to figure out if someone was truly capable of agreeing to a contract? Where do you even draw that line?
Yeah, it's not about drawing a hard line in the sand, but more about looking at the situation, the individual, and whether they were really able to understand what they were doing, what they were signing when they signed it.
Okay.
A really powerful example of this is the Faber case. In this case, an elderly woman, she's experiencing some severe mental decline, and during that time, she ends up signing over her life savings.
Oh, no.
It's heartbreaking. But thankfully, the court stepped in,
Yes.
saw what was happening, and they voided the agreement. They recognized that she was not in position to be making sound decisions like that.
It's so important for the law to protect people who might not be able to protect themselves.
Absolutely.
And it's not always as clear-cut as someone having, like, a diagnosable mental health condition. Right?
You're right. It's not always so straightforward.
What about situations where someone might be, I don't know, under extreme pressure, or maybe they were intoxicated, or just not in a state to fully get what they were signing?
All of those factors can come into play. The court looks at the totality of the circumstances.
Okay, so we've covered cases where one party might not be on equal footing because of pressure or deception or their mental state. But what about when a contract is just wrong, morally wrong? Like, even if both people willingly agreed to the terms, are there limits to what people can legally consent to?
That's where things get really interesting. That's where we get into this idea of public policy.
Public policy.
Yeah, so basically, the courts can step in and void a contract if it goes against what we as a society deem to be, our fundamental values, our basic sense of right and wrong. Even if, technically speaking, the contract seems to have all the right components.
So it's like society stepping in and saying, nope, we don't care if you both agree to this, it's just not okay.
Exactly. And a really famous example of this, one that sparked a huge debate, and rightfully so, is the Baby M case. This one centered around a surrogacy contract. And at first, the contract was actually considered valid. But then, the court took a deeper look and decided it went against New Jersey's policies, their stance on the commercialization of childbirth.
It's a lot to unpack. It makes you realize the law is not this fixed, rigid thing, It has to evolve as our values evolve, our understanding of what's right and wrong. That evolves too.
100%. What might have been a perfectly acceptable contract 50 years ago, 100 years ago, might raise all sorts of red flags today.
Exactly.
It just goes to show the law is constantly having to adapt to who we are, who we're becoming.
We've covered so much ground today. It's so clear that contract law is about so much more than just signing your name on a piece of paper. There's this whole other layer of interpretation of considering the power dynamics, the intent, the morality of it all.
Right, it's multi-layered. And as we move more and more into this digital world with terms and conditions popping up everywhere
You click.
it's more important than ever to understand these nuances. We have to be informed, we have to be savvy, and not be afraid to ask questions.
This has been eye-opening. We've learned that a contract is only as good as the intentions behind it, the fairness it upholds, and the ability of those involved to truly understand and consent to it. Knowledge is power, right? Understanding all of this is what empowers us to navigate this world, the world of contracts, with confidence and awareness.
And maybe even more importantly, it reminds us that while a signature might seal a deal on paper, it's those underlying principles, fairness, transparency, genuine agreement, that make a contract truly hold weight.